We are live now.
Okay, we can start. Shantanu, we can start now.
Rakshita, please take over.
The volume is gone.
A very good morning to everyone present here. I welcome you all to the 10th lecture of Kartavyam, the Constitutional Law Lecture Series by Campus Law Center, Faculty of Law, University of Delhi, in collaboration with top universities and law institutions all across India. An academic initiative aimed at deepening constitutional consciousness among students, scholars, and legal practitioners. This lecture series brings together eminent jurists, academicians, and public intellectuals to reflect on the living spirit of the Indian Constitution. Today, we are tuned in for the 10th lecture of the series. As we celebrate 75 years of Indian Constitution, the Kartavyam series continues to provide a platform for engaging with its principles, exploring contemporary challenges, and envisioning ways to strengthen constitutional governance for generations to come. A very warm welcome to all present for today's session. It gives me great pleasure to especially welcome our professor in charge, Professor Dr. Gunjan Gupta ma'am, and our beloved patron, Professor Dr. Alka Chawla ma'am. To set the ambience for today's proceedings, may I now invite Professor Dr. Gunjan Gupta ma'am to deliver the welcome address.
Thank you, Rakshita. Good morning to everyone gathered here. It is with immense joy, heartfelt gratitude, and a profound sense of responsibility I welcome you all to the 10th lecture in our Kartavyam series, our continuing journey of honoring, interrogating, and living the Constitution of India. This gathering is more than academic exercise. It is, as Dr. B.R. Ambedkar once reminded us, the cultivation of the mind and the refinement of the soul. Each one of you, our honored speakers, respected faculty, and dear students, brings a light of your own, transforming this forum into a vibrant confluence of civic thought, dialogue, and aspiration. The theme for today's session, Reconnecting Constitutional Values, invites us to pause and reflect in an age of rapid transformation and unsettling polarities. It is the timeless principle of Kartavya, duty, that anchors our democratic spirit. As Mahatma Gandhi said, the true source of rights is duties. If we all discharge our duties, rights will not be far to seek. A democracy's strength lies not only in the right it guarantees, but also in the duties its citizens are willing to shoulder. Kartavya jurisprudence calls us to move beyond entitlement towards asking what we owe to one another, to our institution, and to the ideals that sustain our republic. It is my great privilege today to welcome our distinguished guests whose presence enriches this conversation with insight, scholarship, and vision. I take a pride to welcome Shri N. Venkatramanji, Additional Solicitor General of India, a distinguished legal mind whose advocacy continues to influence the course of constitutional law in India. Namaskar, sir.
Namaskar.
I also take pride in welcoming Shri Ranjit Kumar, former Solicitor General of India, an eminent jurist whose counsel has guided the highest constitutional forums of our nation. I welcome you, sir. Namaskar.
Thank you. Thank you. Thank you.
I also take pride in welcoming Professor Dr. Preeti Saxena, Vice Chancellor, National Law University, Shimla, a scholar and institutional leader shaping legal education with clarity and dedication. Madam, namaskar. I welcome you. I also take a lot of pride in welcoming Professor Uday Shankar, IIT Kharagpur, an academic whose work bridges legal theory, policy, and transformative pedagogy. I welcome you, Uday, and let me also tell you he had been an alumni of Campus Law Center and my student. I welcome you, Uday. Namaskar. To our esteemed speakers, we extend our deepest gratitude. Your insights and experience not only guide this discourse, but also reaffirm our shared resolve to uphold justice, service, and democratic renewal. As we commence today's lecture, may it sharpen our intellectual and strengthen our to resolve, to serve, to reflect, to live the constitutional values we hold dear. I once again thank you all for being part of this evolving legacy of Kartavyam, a legacy built on thought, action, and quiet courage of duty fulfilled. I say that we really feel pride that this Kartavyam series is not only limited to the institutions, it has also been raised as one of the questions in Lok Sabha. So I welcome you all. Namaskar. Over to you, Rakshita.
We are privileged to have with us Shri N. Venkatraman Ji, Additional Solicitor General of India. With over 3 decades of distinguished practice, Shri Venkatraman Ji has been a leading voice in the legal fraternity, specializing in indirect and direct taxation, constitutional law, regulatory matters, commercial disputes, arbitration, and intellectual property rights. He has appeared in several landmark cases of national importance, including those on Article 370, the Citizenship Amendment Act, and the Sabarimala issue. Shri Venkatraman Ji's extensive courtroom experience and contributions to key legal developments in the country serve as an inspiration to aspiring legal professionals. I request Shri N. Venkatraman Ji to address the gathering.
Namaste to one and all. Thanks, Seema, for bringing us here. Thanks to Gunjan. Thanks, Rakshita. Above all, pranams to senior Rajit Kumar sir. He's senior in every sense of the term, and I wish that he speaks first, but he is very, very protocolish. So he will say, I have to speak first. So I had chosen to do that. A very, very respected senior counsel for decades in the Supreme Court. Was held the esteem of the institution. So happy to be with you, sir. It's an opportunity. Thanks to Uday and also to Professor Preeti Saxena. Colleagues and dear children, it's a moment for us to feel so glad that all of us are now part of a journey where our democracy and our constitution has traveled and sustained and going in leaps and bounds through the constitutional process and the constitutional developments. When we say 75 years of constitution, is there something to feel proud about it? Is one question as young children may prompt in you, because in the era of information, we get a lot of good and a lot of bad, a lot of neutral, a lot of necessary, a lot of unnecessary. It's a cluster of so many information packaged each. So prompting us to ask this question, what is there to feel proud about our constitution, which has stood for 75 years? In the 15-20 minutes allotted to us, we will not be able to unravel everything in one go. Better we focus on 2-3 facets so that we have a clear idea of what we want to conceive. Ask a question to yourself as children. Close your eyes and look at all neighboring nations of this great Bharat. Close your eyes. Think on your own. All of you are lawyers. You don't need any help to basically conceive ideas, conceive thoughts. Take an independent view. See 75 years of legacy of all our neighbors as nations. And ask a question. Has all these nations survived with their constitution as they started? One question. Two, has the nature of governance remained the same in all these neighboring states? Answer it. You need to answer in your thoughts. Three, have our neighbors amended the constitution several times, or they revamped the constitution itself? Third question. Four, the promised constitutional ideals and the reality of governance, do they match in our neighboring nations? Now ask the fifth question. Should we feel proud? Are we standing on a moment of pride when we declare that the Indian Constitution has sustained for 75 long years and has the ability to move on and on and on for whatever time it needs to? Thanks to 300 odd constitutional thinkers, selfless, passionate contributors who laid the foundational bricks for this constitution to sustain for this long a period. Then, why do we say this long a period? In 1990, 1991, the nation took a very important stand that we should no longer be on our own, we should be part of the global process. So we opened up our options to become a globalized village. And within 35 years, where are we today? The world is undergoing re-globalization again. Nations have started to assert their own rights. Nations are ready to violate international norms, not ready to listen to world trade bodies. The one who feels powerful is ready to bring one who is not that powerful under him. All within a span of just 3.5 decades. Therefore, ask the question, 75 years of sustenance is not that easy. So, we will take 2 or 3 concepts, few minutes each, and then wind up the speech. Concept 1. What is that we feel nice about it, and therefore our kartavyam to preserve it and nuance it and enhance it? One defining moment is when the constitutional bench of our Supreme Court delivered the Article 370 judgment. That's a very important defining moment in our constitutional history, because that moment, through that judgment, we have finally achieved the goal of a one nation and one constitution. It's a very defining aspect in our constitutional history. Now, what do you mean by one nation and one constitution? Why do we say so? The judgment brings out 2-3 important facets. Number 1, union and states are co-equal partners in this federation. First takeaway. A stamp of clear authority and authenticity. States and union are co-equal partners. 2, we should not confuse between federalism and sovereignty. This is a very important distinction brought out in the judgment. An asymmetric federalism or a symmetric federalism is still only a federalism. It is not sovereignty. What do you mean by symmetric and asymmetric federalism? So you should all know the history. 550 states assembled themselves together through the accession policy, and we therefore constituted these states, and we are expanding, dividing, merging states, dividing states based on the democratic evolutions that happen in the regional territories. So when the dispensation of power packages happen, some states needs more help than the rest of the states. So some states have symmetry, some states have asymmetry. Asymmetry is still only federalism. It is not sovereign. That's a beautiful concept brought out in this judgment for young children to understand, taking forward where we stand and where we need to go. See, 7th schedule empowers you through list 1, list 2, and list 3, dividing the subjects for legislation. It gives you legislative power. But that should not make us feel that therefore states have independent sovereignty over the nation. Power to legislate is part of the federalistic structure, which is distinct from sovereignty. We should not say because states have power, states have residual power of sovereignty independent of the center. Wrong. Absolutely wrong. The judgment seals such an approach. To ensure we always remain united and we always represent as one nation anywhere to the world. States is a matter of convenience within our own democratic values. But when we showcase as one Bharat, as one nation, and not as 25 different states or 30 different states put into one basket. No, that's not how we represent. May it be foreign policy, may it be defense, may it be economic policy, may it be signing treaties. Most of things can be put across. Therefore, this is one important piece which in 75 years has made us reach and be very decisive and conclusive. And in the judgment very clearly says, don't search for sovereignty anywhere, because sovereignty is always with the people of India. And states derive power always from the constitution, not from the parliament. These are twin principles. Sovereignty lies with the people, and states derive power from the constitution. Therefore, a journey like this, doing a kartavyam month on month, making children interact on constitutional issues and debates, has a real purpose to serve, because sovereignty lies in each one of us, and we can make our nation proud or we can pull the nation down. So this is one development to remember in 75 years. 2. From this we branch off to a beautiful synergy which we have again arrived in 2017 after 25 years of experiment. 2017 is a watershed moment, but it preceded 25 years of experiment all over India by plural states and plural governments. See, we have been talking about asymmetric federalism and symmetric federalism. Now, we can show to the world we are a very mature democracy because we have also achieved through a constitutional process the unbelievable, what is but yet achievable, what we call it as cooperative federalism. States and the center coming together, irrespective of who rules what, coming together and trying to tax the commodity taxation called the GST as two co-equal partners on a simultaneous levy, which is one. It is one taxable event, one levy, happily shared 50-50 by the union and states. A historic achievement by all of us to claim, happy about it, that we have reached this solution of what is called as cooperative federalism. And how did we achieve this cooperative federalism? Besides the Union Parliament and the respective state legislatures, we have conceived now an independent constitutional body for the first time called the GST Council, comprising of the finance minister of each state, headed by the finance minister of the union. It's a body comprising of the finance ministers of all the states and the finance minister of India. Right. Now you'll all say, what is there? All finance ministers can gather together. What is so great about this constitutional body? There is something to feel very happy about this for two reasons. In democracy, you always decide things only by voting. Voting decides the fate of it. I have another 5 minutes max to go. Yeah. It's becoming restless. I wanted to know whether I should close in 5 minutes.
No, sir. Please.
Please
Another
carry on.
5 to 6 minutes.
Sir, please carry on with freedom. That's not an issue at all.
Well, sir, no, I don't want to make seniors also wait. 5-7 minutes, we'll close it. So, we were here. So, even though it is a constitutional body of co-equals, states and union, this constitutional experiment has tried a methodology which is finding itself very successful. When we come to voting power, 2/3 is given to the states and union has only 1/3 voting power. So every vote, states are 2/3 and union 1/3. And how do you decide a resolution as passed? Not by simple majority. Then it's easy to muster support. It has to be 3/4 every time. So it is 1/3 versus 2/3 at the first step. And in the second step, every resolution should pass only when 3/4 accept it. Therefore, you need the collaboration. Union needs the support of states, and states need the support of union. They have tied themselves together. And in 8 years of its history, 99.9% of its decisions have remained unanimous. Can you believe? Can you believe? Because we read so many things and therefore leave out so many things. Because many things don't come to light at all, unfortunately. So, in 8 years' time, 99, you go and see, log yourself and read it for yourself. 99.9% of the decision-making process has been only through unanimity. Hardly there has been any tussle amongst the states and the union in policy choices. Therefore, we may have politically a symmetric federalism or an asymmetric federalism based on the nature and subject and the need. But we also have a cooperative federalism in the constitutional scheme, making us feel extremely empowered. So, are they not, these two reasons, are they not signs of development? Are they not signs of stability? Are they not signs of vision taking you forward? Now we come to the last piece. All of you are so much filled with information on the tariff war. Today, we are considered to be the fifth or the fourth fastest growing. India is now the fastest growing nation, and fourth or fifth in terms of its GDP enrichment. Now, we are heard in the trade bodies. We are heard in the global spaces. We are part of global decision-making process. We have reached that level of strength out of 189 nations across the world. And we have our own leads. People, smaller nations, developing nations, aspiring nations, nations which have same ideological themes are now coming to us. And after COVID, world has realized that we are a more trustworthy partner in many things, whether it is politics or war or economics or policy choices. We are not fly-by-night operators, and we don't backstab people. So this happens because sovereignty lies with the people. It's the attitude of the people which ultimately flows as in the think tank level. We can't have a disconnect between the two and say something else in the global forum. So today, when nations are sitting on the fence, whether to surrender or to stand up, we are in that moment. In 75 years, we have reached that strength. The nation has chosen not to buckle, but to stand up and see whether alternative options will unfurl itself. There is nothing called a dying moment for a nation. People will say so many things. With 1.4 crore people, with such strong passion and with strong intent, desires to grow, who can break us? Nobody can break us. So everything is a pass. Question is, when you reach those crossroads, these are defining moments in a nation. How you stand up to those circumstances. Stand up, face it, and meet the challenge and find a solution. So it is at this juncture we have convened together to discuss for a few minutes how proud we should be and what is our kartavya. To close it, indeed, Gunjan, I should be thanking you for putting the right phrase of every phrase of Bapuji is always the right phrase, because Bapuji has never spoken a wrong phrase. But most important, what you referred now is important. There are two options whenever it comes to the nation, and it also applies to every home. Should we contribute for the happiness of our home, or it is home that should give us whatever we want? Ask the same question also to the nation. Should we contribute to we should go instead of gross domestic product. All of you should think of gross domestic happiness. We should work into that era. We must go into the era of GDH. All of you should aspire how to make our country happy, prosperous, strong, and stable. The Constitution gives you the way. There will be a struggle. See, you will say, if I say 10 things, you will say 100 things. If you say 100 things, I'll say 1,000 things. It is such a big country. All around how you progress. Are we progressing? Are we kicking, or are we dying? Or are we giving up? That's the point. Bottom line, you have to ultimately analyze. So we need the support of each one of you, aspiring young Indians. See, we are talking of 75, and happily we will all be there when we cross the centenary mark. But more happy, you will all be speaking about it, not us. We will wait and watch in the same screen The students, a batch of students coming out of it and speaking in the centenary year, how India has marched ahead in this 25 years. That's the way we have to look forward very positively. Thanks once again. It's a greatest opportunity to have been with Ranjit Kumar sir in this forum, and all of you. Thanks, Seema, once again for inviting us. Namaskar.
Thank you so much, sir. Thank you. Thank you, sir.
Thank you, sir.
Thank you,
The
sir.
session will be followed by a question and answer session. So, Mohammad Anas, you can ask once at the end of the program. We will open the forum for the question answer round.
Thank you, Sri Venkatramanji, sir. We are equally privileged to welcome Sri Ranjit Kumarji, former Solicitor General of India. Sri Ranjit Kumarji has a distinguished legal career and has represented India in numerous matters of national importance before the Honorable Supreme Court. His rich professional journey and deep understanding of constitutional and public law issues make his perspectives invaluable for our series. I request Sri Ranjit Kumarji to share his thoughts with us.
Thank you very much for this opportunity. And thank you all for being there to listen to us, especially our college campus students who are wanting to know what fundamental duties are. So if you translate Kartavyam, it is duty. And those are the fundamental duties which are made under Part 4A of the Constitution, which were enacted by the 42nd Amendment. So my topic, which I have chosen for me to speak, is on judicial activism and fundamental duties. So I'll say a few things in the beginning about what I feel. There was a famous saying of Wendell Patton that ask not what the country will do for you, but ask what you will do for the country. You should always remember that in this population of 140 crores, it is not that everything can be made available to you by the country. You should be able to contribute in such a manner that the country grows with your help. That is the meaning of that. That is what fundamental duty I would like to expand. The second concept is that my right ends where the other person's right begins. So one should always understand that we should never be encroaching on somebody else's rights. So whenever we are doing something, we should realize that are we within our bounds or are we going beyond the bounds? So keeping this in mind, now let us take the topic of judicial activism. It is a concept which has been appreciated and criticized both. Appreciated because by virtue of this, the courts have filled up gaps where laws are not there or till the laws are made to the benefit of vast sections of the society. At the same time, there is a clamor that there is an encroachment on the executive and the legislative policies of the government. So I will just deal with it in a small time frame that we have. It's a very vast subject otherwise. So whenever there has been a gap in the law, the court has stepped into it for the purpose of, which is called the judge-made law. Now, a judge-made law is now very well accepted world over, and there are decisions on that when a judge is interpreting a law, that law becomes the law of the land and is binding on everybody even while the statute exists. But sometimes when you make that law is also binding, so it's a judge-made law. But supposing there is no law and there is a requirement that a law should be in place so that people who are in need of such situations, you please imagine that in a population of this large figure of 140 crores today, and also diverse needs and diverse factors and diverse communities and diverse thinking, it's not humanly possible for the government to have looked at every aspect. And we should not expect also that the government will be able to manage all of that by itself. Therefore, when the need has arisen and people have brought up the subject before the court, and the court has understood or felt the need that yes, this is some place where I need to step in for the benefit of the larger good, the courts have stepped in. Let me give you a few examples. The right to speedy trial was read into Article 21 of the Constitution way back in 1918, Hussain Ara Khatun by Justice P.N. Bhagwati. He rendered a long line of judgments which are all contained in one volume of the 1981 SEC. That's something, it was read into Article 21, that it is a right of life and liberty, therefore it was read into. Similarly, in Menaka Gandhi in 1978, the right to live with dignity was read into Article 21. Right to education was read into Article 21 till Article 21A was made. So, the Vishakha judgment is the leading judgment on the fact about harassment at workplaces, especially of the female or women gender, or otherwise also. So therefore, the law was enacted in only 2013, Sexual Harassment at Workplaces Act. But the judgment came in 1997. It laid down guidelines and people were bound to follow. So now let me put it in the Delhi perspective. In Delhi, we had 1,018 hazardous and obnoxious industries running here, despite the 1980 Delhi Master Plan saying that they will not be here. Now, all those industries were ordered to be shifted 16 years later in 1996 by a judgment in MC Mehta case. I happen to be an amicus curiae in many of these matters, but I don't want to elaborate on that. So all these industries were shifted out of Delhi to try to bring down the pollution. The right to live and live with dignity includes the right to live in a good environment with no pollution. So therefore, you have this right which was inculcated, and 1,016 industries left Delhi for good, and they are settled elsewhere and they are functioning well. There were people who were living in government quarters for decades. They were not leaving. They were asked to leave. How? So the court stepped in and said, why are you occupying government quarters? Public has an interest in it also. After all, government quarters and is all being run on public money from the tax department. Then there was mining going on in Aravalis like it's nobody's business. Now, all those mining was stopped in 2002 because even though the metal may be right, but the Aravalis is the second longest chain of oldest ancient mountains for India, and it acts as a buffer to stop the desertification of Delhi. There is scientific evidence on this, that if these mountains were not there, Delhi would be desertified because of the winds blowing from the west. So the kind of excavations that were going on, the court stepped into it, and the Aravalli minings were closed. So I can give very many examples on this, like the Ganga pollution or the Yamuna pollution, etc. The DCM Mills case, which started in '85, this on a postcard petition given to which Justice Bhagwati treated as a writ petition, started with that smoke, which had caused people. Some people died because of the. So the question is that what did the court do right or wrong? Now the Environment Protection Act came in 1986, but before that you had the Air Pollution Act, you had the Water Pollution Act, you had the Forest Conservation Act in 1980. The 1980 Forest Conservation Act is a very, very all-encompassing statute. Yet, a lot of time what happens is laws are more followed in their breach than in their application. So why did T.N. Godavarman case start in 1996? Justice J.S. Verma and Justice Kirpal started the T.N. Godavarman case as a letter petition again, and also gave a definition to what is forest, which is defined in the Forest Conservation Act 1980. Today, our forest cover, if you see the Forest Survey of India report today, the increase, because the forests were being degraded like anything. You take the Dehradun Hills. In the Dehradun Hills, mining was going on, and the entire forest area was being degraded, and which all these leads to climate change. If you are looking at the climate today in the hills, look at what is happening in Uttarakhand, or look at what is happening in Himachal Pradesh. There is devastating tragedy. Now, that is why I say this is followed more in law, is followed more in its breach than it's in application. So the court stepped in. The court stopped the Dehradun mining. If you have gone to Dehradun recently, the forests are back there on those. The mining was stopped by Justice Ranganath Mishra way back in 1989-90 in a judgment rendered in Rural Litigation Entitlement Kendra, it's called. So I am saying that judicial activism serves a purpose. One should not think that it does not serve a purpose, because if it is for the larger good of the mankind, of our society, of the needs of our society, it is right that the court stepped in. Let me put it the example of the Constitution Bench judgment, which recently came in 2023, headed by a bench of Justice K.M. Joseph. That was regarding the choice of election commissioners. There, in a series of paragraphs, the learned judge has noted what the law on judicial activism is in different countries of the world, and thereafter come to the conclusion that if the court was stepping into it for the purpose that an election commission, being a most independent body, should be chosen in a manner that judgment has been rendered. So judicial activism is something like our constitution. It's a ever-changing document. The constitution does not have fixed notions. You have to apply the constitution, read the constitution as per the change of times. And there are judgments that this judgment on the parliamentary committee reports be considered as evidence. In Kalpana Mehta's case, the Chief Justice Deepak Mishra has said about that the constitution is ever-changing document, ever evolving, I would say. It's not, let's not say changing, ever evolving document. So the application of the laws where the law is in place but not followed or followed in its breach, or where there is a gap in the law, and the gap, like the MC Mehta cases, there was a gap. court stepped in and felt it. So that is my take on the judicial activism part. So far as fundamental duty is concerned, which flows with judicial activism for this reason, that first of all, a lot of persons understand that part 4A of the Constitution goes with part 4, where there is an Article 37 which says that you can't enforce the directive principles. In my respectful submission, part 4A does not have any such kind of prohibition or a restriction that this can't be implemented. You look at it, when it was made, there is no such restriction. There is an Article 51A, and this says that these are the fundamental duties expected of our person. Now, why does it run like that? In my humble opinion, according to me, every right is coupled with a duty, with kartavyam. So, in our 75 years of the Constitution, if we are not able to fulfill our duties to the nation, then we are not growing up as a society in a manner in which to achieve our highest, the 2047 aim, that we will be completely on top of the world. So, and there are judgments. Look at the national anthem part, is part of fundamental duties. It was enforced through a judgment of the court. So that is just one example. Ranganath Mishra, after his retirement, wrote a letter to the then Chief Justice, which was heard by a 5-judge bench in 2003, where he says that you must give a statutory color to the fundamental duties so that people are expected to follow what is expected of them as a citizen of this great democracy. That judgment is there already on record in 2003 and thereafter by a 3-judge bench. So one can't say, if you talk of judicial activism and fundamental duties, I am saying both go hand in hand. Supposing I were to file a case which there was a gap in the law, I must also see whether I am trying to fulfill a fundamental duty which is enshrined in the Constitution, which is for the welfare of the larger democracy. So those are my views. I think I have exceeded my time. Thank you very much. Very kind of you to hear me. Thank you. Thank you.
Thank you so much, sir. Thank you so much.
Thank you. Thank you for this opportunity.
Thank you, sir, for sharing your thoughts with us. We are delighted to have with us Professor Uday Shankar, sir, from IIT Kharagpur. Professor Uday Shankar ji has made substantial contributions to academia through research and teaching that bridge the disciplines of law, economics, and policy. His supervision of doctoral and postgraduate research has focused on pressing social issues such as poverty, health inequalities, education disparities, agricultural technology, and inclusive development. Through his interdisciplinary approach, he has helped shape policy perspectives that resonate beyond the classroom, influencing the broader discourse on constitutional values and social justice. I request Professor Uday Shankar ji to share his insights with the audience today.
Namaskar to everyone. Indeed, a matter of great privilege and honor for me to participate on a very time-based and context-based program on focusing on kartavyam or duties. And adding to it is organized by my alma mater. Thanks to Professor Seema Singh and Professor Gunjan Gupta for extending the invite and giving me an opportunity to share my thoughts on it. What I'll talk in next 15-20 minutes is about the enforceability and justiciability of fundamental duties. I'll just try to build an argument that it is, when we talk about the duties, let us not look at only from the perspectives of citizens coming forward and looking at the significance of duties from individuals' perspective. Even institutions have a role to play, and in that process, the judiciary has a larger role to play. And on that premise, I build the argument. It is really very enriching one to listen to two eminent speakers before me. And taking forward the debate, I would say that when you look at the language of the law, there is always two kinds of content in the language. One is the communicative content of the law, and other is the legal content of the law. And it is suggested that we shall look at both the contents in order to understand the idea underlying behind any provisions. So for that matter, I believe that for law and understanding the legal provisions, vagueness is virtue. It works in advantage of both the law and legal system and the beneficiaries of the law. And that's how I look at the structuring of fundamental duties under the Indian Constitution. While introducing or incorporating fundamental duties, the parliamentarians were well aware about the language used in the context of Article 13 and 37. 13 in the context of fundamental rights, where categorically a mandate has been given to the state to not to violate the rights, and any such endeavor, any such attempt shall be considered to be void of initio. The language of Article 37 clearly spelled out the responsibility of the legislature and the executive, highlighting that enforceability of the principles, directive principles, shall not be by any court. Now, when I look at the fundamental duties, part 4A, I try to find an answer that what made the parliamentarians, while exercising the power under Article 368 or exercising the constituent power, not to go by either the flavor of Article 13 or advisory of Article 37. Why they have decided not to make it enforceable or obligating the state, or at the same time clearly spelling out that the other two branches of the state other than the judiciary should be made responsible for the duties. Though the opening statement of Article 51 capital A says that it shall be the duty of every citizen. But how do we really look at it? Should it be really looked at it only from the perspective that it is citizen-driven constitutional mandate, or Part 4A plays a significant role in guiding all institutions, prominently the judiciary? For building this argument, I will try to bring in certain instances from the judicial intervention, that how the judiciary has looked at the content of 51A, fundamental duties, in relation to other provisions of the Constitution. So in my conversation, I'll be looking into these questions, that whether fundamental duties are enforceable in nature, whether fundamental duties are to be read with fundamental rights, and whether the judiciary has the sort of competency to enforce fundamental duties. As I said, that the languages not in the part 4A is not resembling 13 or 37. What does it mean? Does it convey that the absence of such a provision indicate a different course of interpretation adopted for part 4A? Though we are aware of the fact that when the fundamental duties were being discussed on the floor of the House, a suggestion to make it enforceable was rejected by the parliamentarians. But then we are looking beyond and trying to understand that how through the judicial process fundamental duties have been given effect. Instances are there where the Supreme Court was approached for giving effect to fundamental duties, or Supreme Court is petitioned to enforce fundamental duties. For example, way back in 2003 on an issue of giving prominence to fundamental duties for better citizenry, in Ranganath Misra case, it was highlighted that this must become a part of learning on day-to-day basis at the school level, and thus the Supreme Court has directed the central government to take all necessary steps to implement fundamental duties as it has been recommended in Justice Burma committee report. We do have an instance from recent time, 2022, in Durga Dutt case, where again on an issue of enforcing fundamental duties, a petition has been filed with a direction that union shall be directed to provide incentives to citizens to adhere to fundamental duties and to set up independent high-powered committee to scrutinize and review the legal framework on fundamental duties. Now the question is, how do I really look at the role of the judiciary? Because 4A does not explicitly prohibit the enforceability. And thus, one may try to look at the role of judiciary in a much more decisive way on the issues of duties. Because we try to look at it that whether any breach of fundamental duties may warrant the initiation of legal proceedings. In fact, we do have an instance where duties are being formulated in terms of a statutory framework. For example, the law on mentioning senior citizens and elderly people, or for that matter, the ongoing debate in the state of Kerala on having a policy to see the welfare of elderly people. Part 4A has been read in in relation to Part 3, fundamental duties. In fact, this fundamental word somewhere indicates that it is something not to be overlooked, and not to be overlooked when necessary occasion comes before the court. So, for example, in Kaushal Kishore case, the court certainly has looked into this very relationship and said that the permissible content of the right to freedom of speech and expression ought to be tested on the touchstone of fraternity and fundamental duties. So instances are there where 19(1)(a) has been read, with a, in relation to Article 51, capital AC. So the court, through its interpretative role, has given an attempt to enforce fundamental duties by reading them to determine the scope and content of fundamental rights. Now, when I look at other approaches of the judiciary, there are instances where the court has also highlighted that fundamental duties are obligated one, but need not be seen as enforceable one. For example, in Minroa Mill, the court has highlighted on this very aspect that there may be a rule which imposes an obligation on an individual or authority, and yet it may not be enforceable in a court of law, and therefore not to give rise to a corresponding enforceable right to another person. Or for that matter, in a case which was also referred by the previous speaker on Anup Barnwal case, where the court has said that the values that animated the freedom struggle have to be brought home to a new generation through the insertion of the provisions relating to fundamental duties. So court has highlighted on this very aspect that let it be a matter of obligation, but let it not be made very legalistic. Now, this is the advantage which I am saying, or I started with, that when the provisions are not very clear, certainly, you can always look at the positive side of it and make a constructive contribution in the entire discourse. So fundamental duties may be regarded as an obligation, yet their non-enforceability may become an issue, that whether the non-enforceability is somewhere adversely affecting the very status. That's what one can argue and engage into the discussion with regard to the role of fundamental duties. For example, in a judgment given by Madras High Court in L. Chazian case, where the Madras High Court made a very, very pertinent remark, and the court has said, if I quote what has been stated by the Honorable Court, time has come for the courts not just to be senatorial on the qui against the state's attempt to invade the constitutional rights of the citizens, but also against plotting tendencies of the citizens not to abide by their constitutional responsibilities or duties. The latter may not be enforceable, yet they cannot be ignored. So court emphasizes upon this. There are also instances where the court has acknowledged the limitation in terms of enforcing fundamental duties. For example, in a very landmark judgment on AIMS Students Union related to affirmative action, court has said that fundamental duties are not made enforceable by a writ of court, just as the fundamental rights are, but it cannot be lost sight of that duties which are enshrined in Part 4A of the Constitution. And there the court emphasizes upon this prefix fundamental, which was there with both Part 3 and Part 4A of the Constitution. There are instances where the court has also expanded the scope of 51 capital A, like in the same case of AIMS Students Union. The court has said that is, or read that this state is representing the citizen, and thus there is a collective responsibility of the, of the state to, or there's a responsibility of the state on behalf of the people, on behalf of the citizen to give effect to the fundamental duties. So the court says in AIMS Students Union that a state is all the citizens placed together, and hence through 51 capital A does not expressly cast any fundamental duty on the state. The fact remains that the duty of every citizen is the collective duty of the state. So court has expanded the scope of 51 capital A. Moving ahead and trying to build an argument that how important interaction is required between the judicial process and then the intent behind fundamental duties, court has looked into also that to what extent fundamental duties can play a significant role in examining the constitutional validity of a law. In a significant case of a state of Gujarat versus Mirzapur Moti Qureshi Kasab Jamaat, the court has highlighted that both fundamental duties and the directive principles, they play a significant role in drawing a kind of boundary for the legislative measures taken by the government. And that process, the court has looked into the fundamental duties in order to validate the provisions of the law, or to examine the provisions of the law. Similarly, when you look at the case of Yamuna Shankar Mishra, which is with regard to writing a confidential reports and making entries in the character roles, or in a service matter, the court says that this is something which gets a support from 51 capital A J. So when you look at it, you'd find that the court has been acknowledging the significance of fundamental duties. For example, again in a very significant matter which has been decided last year, Property Owners Association versus State of Maharashtra, again the court highlights on the role of 51 capital A, says that this is something which is based on the noble ideas which inspired our national struggle for freedom and played a significant role in in promoting the idea of brotherhood and developing scientific temper, and thus the duties which emphasize upon educating the children and duty to strive towards excellence in all spheres must be given a due importance. So the court has said that while understanding that what 39B talks about of material resources and such material resources committed for larger common good, court says that 51 capital A is certainly to be taken into account for deciphering the ambit of 39B. Similarly, the court has taken note of fundamental duties for examining the right of every citizen with regard to flag hosting or respecting, the national symbols in Naveen Jindal case, or for that matter, Vijay Emanuel case. Court has looked into this. Court has also looked into the fundamental duties, not only for giving an interpretation to the constitution, also to statutory law. In a famous case of Animal Welfare Board versus A. Nagaraj, court has looked into the prevention of cruelty, against cruelty of animals act, section 3. The court has said that 51 capital AG has a significant role to understand that how the law should be given effect when it is all about protecting, cruelty against animal. So there are instances where the court has played a significant role in creating a new charter for the fundamental duties. And that's why what Venkatraman sir was telling right at the beginning, that 75 years we have moved ahead, and all these provisions have played a significant role, and judiciary as an institution has made a very decisive, kind of intervention in highlighting the significance of these provisions of the Constitution. Fundamental duties has also served as a guidance. For example, in case of Om Prakash, the court has said that fundamental duties enjoined on citizens under 51 capital A, and it should also guide the legislative and executive actions of elected or non-elected institutions and organizations of citizens, including the municipal bodies. Instances are also there where this fundamental duties are made applicable in relation to policy. In the case of Gene campaign versus Union of India 2024, the court has highlighted that when you are talking about genetically modified things, you must look at also that how this DPSP and fundamental duties can play a role, particularly in relation to protecting protecting the environment. And that's why the court has emphasized that the policy with regard to GMOs must get guided by provisions which are there in fundamental duties, particularly 51 capital AG. So instances are there. There are also instances of enforcing fundamental duties. For example, the case of Syam Narayan Chauksy, where at one point the court has said that when the all cinema halls shall play the national anthem, obviously further the court, it has been diluted, and it says that one has to pay the respect with regard to the playing of the national anthem, and the court has said that in 2018 that prescription of the place or occasion has to be made by the executive, keeping in view of the fundamental duties provided. So court in a way has highlighted on the very significance and attempted to make it enforceable as well. So towards the end, I must say that the very absence of the provisions which are there for 13 or 37, one for the fundamental rights, the other for the directing principles, that absence somewhere has been rightly used for the larger benefit of the cause of fundamental duties. Courts are reading the scope of fundamental rights and directive principles by applying or relying on fundamental duties. So they are not enforceable per se, but they are certainly playing a significant role as an interpretative tool of the in judicial decisions. And that's the reason I strongly believe that when we are celebrating the success of 75 years of the Constitution, and incidentally, IIT Kharagpur is also entering into 75th year of its establishment. I believe a very valuable input has been made by the judiciary, and every institution has a role and responsibility to play in order to see that duties become matter of debate, discourse, and debate, discourse, and discussion on day-to-day basis through judicial pronouncement, through executive actions, and most importantly through our individual conduct. Thank you very much.
Thank you, Uday sir. Thank you so much.
Thank you, Professor Uday Shankar sir, for sharing your insights today. Finally, I would like to invite Professor Dr. Preeti Saxena ma'am, Vice Chancellor, National Law University, Shimla, and the chair of today's session. Professor Dr. Preeti Saxena ma'am is a distinguished academic and administrator with a career devoted to legal scholarship, research, and leadership in higher education. Her work reflects a deep commitment to fostering academic excellence and strengthening the legal fraternity. Her exceptional contributions to academia have been recognized through honors such as the Best Academician and Administrator Award 2016 and the Best Publication Award 2013, along with her selection for the Ministry of Education's Leadership Program in 2019. Her dedication to advancing inclusive and innovative legal education and preparing students to address contemporary socio-legal challenges continues to inspire generations of law students. I now request Professor Dr. Preeti Saxena ma'am to deliver her concluding remarks and formally conclude the session.
Thank you, Rakshita. So, good morning to one and all. My thanks to Professor Seema Singh, Professor Gunjan, Professor Alka Chawla, the entire Central Law Campus University of Delhi for visualizing this wonderful project Kartavyam. And I'm also feeling very, very proud to be associated with Kartavyam as one of the partners. I'm also very much honored to listen the constitutional visionaries, Honorable Shri Ranjit Ji, Shri Venkat Ramanji, and my colleague, Professor Uday Shankar Ji, on the 75 years of the Constitution of India. The discussion so far were on the judicial interpretation of constitutional provisions, judicial activism, like Article 370, One Nation, One Constitution, cases on the fundamental duties, on their enforceability as per the text of Part 4A vis-a-vis Articles 13 and 37 in Part 3rd and Part 4th, respectively. However, I'll try to see Kartavyam on 2 points. The concept of dharma, Kartavya, and seva that we know have been embedded in law, morality, and culture for millennia. And second, the constitution that was originally enacted in 1950 had no separate chapter on duties. So basically, this raises two central questions. One, how were duties an integral part of India's knowledge system, knowledge traditions? And why did the Constituent Assembly, despite this heritage, not place duties alongside rights in the original Constitution? India is the nation in the world which is having a long history of democracy. In 1950, we have all seen the birth of the world's largest democracy. And here we see that citizens, they have a reputation for carrying out their duties and obligations. The kartavya of an individual is the fulfillment of his or her duty towards the society, towards the nation, and of course, towards the parents. And we know that this has been emphasized since time immemorial, as rightly observed by Professor Gunjan Gupta also, regarding the viewpoints and opinion of many of our distinguished leaders, authors, jurists on the duty part, as rightly Mahatma Gandhi's opinion about duty, that the very performance of a duty secures us our rights. So there is no need to have the right. If we perform our duty, that will surely result in our rights. So rights cannot be divorced from the duties. So this was the viewpoint, and we are also having all this in our culture. Rightly told by Swami Vivekananda also, he's also observed that it is the duty of every person to contribute in the development and the progress of nation. So nation is on the upper hand, and we have certain duties towards the nation, towards the society. And we see that the 2 points which I have raised regarding how it is embedded in our culture. So we find that India's intellectual heritage is grounded in a duty-oriented worldview. The idea that the individuals are bound by the duties towards the society, towards the nation, and this predates modern legal system that the Constitution of India we are talking about. And this approach can be seen in multiple sources, wherefrom we have this duty concept in our culture, in our tradition. If we see the Vedika, the Vedas and the Upanishads, so that we have a tradition. In Vedic thought, dharma is not merely a law, it's a moral order. It is an order that is governing the cosmos and the human behavior. So duties are embedded in the life stages also, like various ashrams we are talking about, or various social roles that ensures that each individual has to contribute to the collective good for the society, for the nation. If we see Rig Veda, then we find that Satyam, Vada, Dharmam, Chara, these are some of the values which are there, the duty of speaking truth or the righteousness and to service to the society. And again, if we see the Upanishad, then we find that it is speaking of the self-discipline. It is speaking of learning and respect for the parents. It is speaking of the respect for the teachers. And this is also talking about the obligations of the students, brahmacharya ashram. So in our Vedas and Upanishads, we find that the kartavya was there as the basic value. Then if we see the epics and our history, itihas, if we see, then we find that our epics like Ramayana, Mahabharata, they are replete with the narratives where characters face moral dilemmas about their duties. And we all are aware about the Bhagavad Gita, where the Krishna's he counsels the Arjuna to fulfill his swadharma, personal duty as a warrior, even when he was emotionally conflicted. Karvanya Vadika Raste, we all are aware about that you have the right to perform the actions, your actions, but you are not entitled to the fruits of your actions. So these were the things which emphasizing on the nishkarm or nishkam karma, that is performing the duties without any attachment to the fruit. So this was also one of the concepts which is embedded in our culture in which we are living. Then if we see our smritis and dharmshastras, then we find that the texts like Manu Smriti and Yajnavalkya Smriti, that also codifies duties for the rulers, for the citizens, for the householders even. And they regulated all these to regulate the social life. And these were the duties which were said to be sometimes the reciprocal obligations also. so that the rulers have the duty towards the citizens, and the citizens have also the duty to obey the laws. And in that way, that is basically to uphold the societal order. So all these were found in our texts, which were available now. And along with that text and Dharmashastras, if we see that during various times, whether it's the time of the Buddhism or Jainism, so they have also contributed towards these types of the ethical values, which is known as the karuna, that stress upon the compassion, or that stress upon the ahimsa also, to not to harm the others. So these were certain things which I found that they are the part on which all these duties centered as a guideline. If we talk about the Jainism, then we find that vratas, various vratas, or with its vows of truth and non-violence and restraint, these are equally focusing about on the obligation over the rights. During medieval time also, if you see the bhakti saints like Tukaram, Mirabai, Kabir, so you find that their stress is always on the moral duty to love, to serve the society, and to uplift the fellow beings. So this is all transcending caste and creed, and the very purpose is service, that is seva. That was both a spiritual and a social obligation. So if you see your tradition, if you see the bhakti saints, if you see the contributions of the Buddhism or the Jainism, if you see our Upanishads or our Vedas also, so everywhere it is replete with the sense of kartavya. It's an obligation, it's a service, it's a seva, it's a brat, it's a karuna, it's a ahimsa, whatever you say. So we find that this moral duty is always available there. So we find that in essence, the Indian traditions, they never treated duties as optional virtues. They were the moral foundation of the social life, and that social life that was governing the society. But if we talk of the modern constitution discourse in India that we have adopted, we have enacted, we have taken to ourselves or given to ourselves on 26th November 1949, and that has been enforced from 26th January 1950. So it often focuses on rights, civil rights, political rights, social rights, economic rights, and cultural rights. Yet the Indian philosophical and social legal tradition has long placed these duties at the heart of the social harmony and the governance. As I was hearing Honorable Shri Ranjit Kumar ji, who has rightly said that the rights are coupled with the duties. And I'll just try to give one example that how these rights are coupled with the duties and why we were not having the duties in the original constitution. So just take the example of Article 19, Clause 2. Now, Article 19, Clause 1, that provides us various fundamental freedoms: freedom of speech and expression, freedom to travel, freedom to reside, freedom to assemble and association. So all these type of freedoms are there. But if we see Article 19, Clause 2, then you see it just provides for the restrictions. And these restrictions are nothing but these are the duties towards the society, towards the nation, by putting sovereignty, integrity, friendly relation, decency, and morality, that you have a right, but your right is restricted. And that restriction is nothing but that is a duty. And that's why, as rightly told by Shri Ranjit Kumar ji, that rights are coupled with duties. And therefore, I find that the constitution makers initially, they found that it's a time that all the rights are to be given, but not the absolute rights. And that's why any of the restrictions upon that is to be considered as a duty. So finally, I would say that the duties or the kartavyas that have been the central to India's moral, legal, and philosophical heritage, whether it be the ancient texts, epics, religious traditions, or even pre-colonial and colonial governance also, they all emphasize the obligations over the entitlements. So entitlements or rights are secondary, but obligations and duties are the basic for a social order, for a society to be governed by the rule of law. Hence, the only thing we need is to activate ourselves. This is the time that we need to activate ourselves towards what are our kartavyas. And I appreciate that this is a visualization of Delhi University, particularly Department of Law, Faculty of Law, that they have come forward with this vision that we are talking only about the entitlements. We are talking only about the rights. This is a time that we must also emphasize upon the obligations. We must perform our duties, because this time again we need to fulfill those vision of Mahatma Gandhi that to do our duty is our right. So we should not wait for the rights to come. We should perform our duties, and this is the time to activate ourselves towards this kartavyam, towards the duties. We have to follow our duties. This is enforceable or not enforceable doesn't matter. It is we that we have to perform, because nowhere, as rightly observed by Professor Uday Shankar ji, that nowhere it is mentioned under Article 51 capital A that whether it should be enforceable or not enforceable. These words are missing in the text. It only speaks about it shall be the duty. And if we see the judicial interpretation, shall always means that you have to do. And that's why we need to be activated ourselves. We need to disperse them among others also that this is the duty. You have to perform your duties. So once again, I congratulate Team Kartavya and particularly Professor Seema Singh ji for this very, very thoughtful project. And I am very, honored and privileged to be associated with you. Thank you very much.
Thank you,
so
ma'am.
much. Rakshita, now we can start with this question answer round.
Yes, ma'am.
So those who want to ask question, please raise your hand, unmute yourself, and then ask question with the concerned person. Over to you, Rakshita.
Yes. Thank you, ma'am, for sharing your wonderful insights. Before we conclude the session, we welcome questions from the participants. If anyone has any question, please kindly you can unmute yourself, or you can put the message in the chat box.
Siddharth, you can ask question. Please unmute yourself. Siddharth.
Very good afternoon to everyone. It was a wonderful session altogether. I just wanted to appreciate for taking a step forward to conduct this whole series of lectures. So that's what I wanted to convey. That's all. Thank you so much.
Thank you, Siddharth. Thank you for your kind words. Shantanu?
At the outset, I would like to thank all the esteemed speakers for this thought-provoking and intellectually enriching session. Sir, my question is to Honorable ASG. Sir, do we ignore the role of the inherited Bharatiya ethos while we celebrate the endurance of Indian Constitution?
Rakshita, please mute yourself.
I'm not able to hear you. Yeah. Please. Yes, Shantanu.
Shall I repeat my question, sir?
Yeah.
Okay. So, sir, my question is, do we ignore the role of the inherited Bharatiya ethos while we celebrate the endurance of Indian Constitution?
Oh, no, not at all. It's not possible. Then we have lost the whole text of what Professor P.T. Saxena spoke. Okay. See, she has one new dimension she has brought, and it's very valuable. When we keep speaking, fundamental duties are paramount, as fundamental rights are. Now, both Ranjit Saab and Professor Preeti Saxena called out a new dimension to say world order and expectations of the cosmic order demands you to follow dharma. And dharma, what are the ingredients of dharma? Can you define dharma? Difficult. But what are the ingredients of dharma? It says head on the right place, love in the heart, courage and vision in the body, and compassion to the world. Components together make a person dharmic. So can you ignore these ingredients and say you can still pursue a constitutional course? You will fail. So it's not a question of endurance. It's a question of being a bedrock of it. That's how we should put it across. Good question, and thanks a lot.
Thank you, Shantanu. Anybody else? Venkatraman sir, can I ask one question to you? Pawan, please ask a question. Unmute yourself.
Thank you, ma'am, for giving me this opportunity. This question is very generic, as it is rightly said that don't ask what the state can do for you. Ask yourself what you can do for the state or the country. But the thing is, sir, in the concept of state, the citizens of this country has given up so many rights in favor of the state to take care of the basic things. So when the state failed to ensure that basic things are being taken care of, then why the state should expect the citizens to, do the basic duties? So how do we balance this? I mean, we see in day-to-day life that there are some failures from the state side. So how do we balance it? Any one of you can take over, sir. Thank you so much.
Who should take when decide?
So you can take over, sir. Thank you.
Ranjit sir, can I take it?
Please.
Yeah, thank you.
Welcome, very welcome.
Yeah. If anyone wants to add also, you can add. See, there is a story. In a village of 500 people, there was one day they found out shortage of milk. So the village headman said, it's difficult to gather 500 liters immediately from any source. So each house will put a big tank in the middle of the village. Each house is expected to pour 1 liter of milk into it. So that it's a collective contribution. We will get 500 liters by the afternoon to meet that requirement. So there was a lid which was also placed on a big vessel. So after 4 hours, the villageman went and opened the lid, and he found out 500 liters of water instead of milk. Because every second person thought, somebody will pour milk. What's wrong in me pouring water? Unfortunately, all the 500 thought the next man will pour milk. So this is what is called as collective consciousness. You can't say, Constitution has not done this to me. Government has, therefore I can do anything I like. If they have not done, find the way how they will make it do. There are means and ways to do it, to enforce it. But does not mean till everything falls into place, I can be what I like. Then you are not part of the whole. See, it's a journey. As children, you should certainly understand constitutional democracy is a long-term vision, long-term journey. It's like a train which starts from one destination and lands after 3 days in another destination. Passengers get in, passengers get out. The train will keep going. So you need to run it. And when you want to run it, the ideal, the first preliminary request would be, you should be part of it and not outside it, and want to see whether everybody else performs. Don't be a receiver, become a contributor. Then you can demand a few things. System will listen. Unless you contribute, then you will say, see, the neo views say this. See, we pay our taxes. We draw our salaries. Now UPA has come. We are all paying everything and accounted. We are following the norms. So our job is over. Paying taxes is your duty. It's not something which you are doing it as a gift or a donation. It's your duty. So, by performing or paying taxes, if you feel your democratic connections with the nation stands completed, then how do we run it? Especially advocates. You need to see, advocacy is something to do with the social pulse of the nation. Whether you like it or not, whichever branch of law you may practice, you will be connected. Ultimately, the substance of your connection will be some part of the human society. Or in your era, machine society. You will be connected with some substance. So you must have this commitment of being part of the mainstream. If anyone wants to add, please.
I just want to add one more dimension.
Yes, sir.
My friend, Mr. Pawan Kumar, said that if the government has taken over many things, but it is not performing better, how can I help? I am saying you have many ways to help. If supposing the government is not performing according to the way it is, should you apply under RTI? Today it's a very powerful legislation. You get the documents, you get the papers, and you go and you can tell the court, see, the government took over this function, but the government is not performing. That is what, and then you bring it to the notice of the authorities first. You go, there is a process within the authorities where you have a departmental appeal, this, that, etc. And thereafter, and you can bring it, or you can also put it across. There are very many ombudsmen on very many things. There is Lokayukta, Lokpal. Then if still nothing happens, you can go up to the right up to the court. What is this PIL, public interest litigation, is also where there is a gap in the performance of the government. So if the government does not perform for any reason having taken, you have a duty to bring it to the notice for the general common good, for the larger good, because you have understood that yes, this is not happening the way it should. You bring it to the, you get it rectified. Why should you sit back and say, government was supposed to do it, did not do? What do I do? You have many things to do. That will be your contribution to the society. Thank you.
Thank you so much, sir.
Uma, can you excuse me?
No, sir. Yes, obviously, sir. Now we are going to close the session with the vote of thanks. And there are a few takeaways points which are very important and which are the crux of this entire session. So first of all, I extend my thanks to Venkat Raman, sir. And sir, the one line outcome which I wanted, especially I wanted to draw from your lecture is protection of the interest of the nation and the sovereignty. That is our prime duty. That is our prime kartavya, and it is also, I think this is the reason that our preamble also begins, the first word which is used in the preamble, that is the sovereignty. So you have discussed different aspects of federalism, and that was very enlightening for all of us, how we have traveled a lot since 1950 to 2025, from unitary form of the government to cooperative federalism, competitive federalism, fiscal federalism, and now this symmetrical and asymmetrical federalism. So thank you so much, sir. Thank you so much. And Ranjit sir, judicial activism, obviously a very favorite topic for the judiciary and as an academician for all of us. So kartavya of judiciary towards the constitution is very much important. But ati kartavya is also sometimes it is problematic. So the overactivism of judiciary, so that is something, and it also reflects one idea that we should also decide the limit of our kartavya. So excess of anything may be bad, even the excessive performance of duties also. And Uday sir, thank you so much, sir. And you have given a new dimension, and you very clearly elaborated different dimensions of duty: duty towards nation, towards environment, towards government, towards family, towards society. And duty is a complete package. And ultimately, we can say that right cannot be enforced without duty. But if we are performing our duties, we are entitled for our eligible rights. प्रीति सक्सेना मैम, थैंक यू सो मच. और आपने एक बड़ा अच्छा जो बात बताया कि कर्तव्य is an obligation. It is there to balance the conflict in the society, and it is definitely a spiritual and cultural obligation upon each one of us. So with this, I extend my gratitude to each one of you to give your precious time on this Sunday. So thank you to all of you. Thank you to my professor in charge. And
Thank you,
to all
Seema.
the,
Thank you.
thank you, ma'am. Thank you so much.
Thank
Or
you.
all
Thank
the
you very much.
advocates who have joined from the different part of the country, from Kashmir to Kanyakumari, because some people have joined from Sikkim, some from Kerala. And thanks to each one of you, thanks to the entire team of DDS, of faculty of law, all the faculty members. And from 18th, we are going to, appear before all of you online as well as offline. So 18 तारीख को Monday को we will come up with the new lecture, and the details will be given to you in next few days. So with this, thank you so much, sir. Thank you to all of you. And ma'am, with your permission, can we close the session?
Thank you very
because
much.
I know the time of everyone is very
Seema,
precious.
I would also personally thank each one of you, sir. It was really enlightening, and we are privileged. And we, in fact, you were saying we should give you time. We are saying we couldn't give you so much time, but we would invite you certainly here, sir. Once again, thank you from Campus Law Center.
Thank you so much to all of you, to all the seniors. Thank you. Thank you.
Thank you.
Namaskar.
Thank
बहुत
you.
धन्यवाद आप सबका. Thank you. Now we can close the session.